Hello viewers, this is Attorney Naresh Gehi, and with me as always I have Sandeep from my office, who is my manager, and today, based upon the demand from our viewers, we are going to talk about the K-1 visa. The K-1 visa is very often referred to people as the Fiancé Visa. A lot of people from the United States, especially American citizens, intend to visit their fiancés abroad and get them to the United States. So today we are going to discuss the procedure of how you can get your fiancé into the United States as soon as possible. And joining me, as I mentioned earlier, is Sandeep Nair. Welcome, Sandeep. It's a pleasure being with you on the show. And are you planning on getting your fiancé to the United States? Or that's why you chose this topic? Or what's the secret behind this particular topic today?
I'm currently single right now. That's the reason why this topic was chosen.
All right. So in a way, are you trying to fascinate people, especially around the globe? Especially as you know, we practice immigration from every particular nation in the world. So are you trying to attract someone from there so that you can go and visit her and get her here on the fiancé visa?
I guess we'll find out after the show.
All right, we're going to find that out. So that's going to be a separate talk. And do you want my viewers to know that we're going to have a separate show on that issue?
Oh, not necessarily.
All right, so let's get started with the fiancé visa. And this is Attorney Gehi. And Sandeep, let me first give our viewers a clear background of what is the fiancé visa.
Yeah, that's good. Okay, perfect.
Under the immigration and nationality laws of the United States, an American citizen can sponsor his fiancé to come to the United States. A fiancé is a person under the law who is intending to get married to this American national who lives in the United States. An American national here means an American citizen. And the law on the point is that you should have a bona fide relationship. And if you intend to get married to this foreign national after he or she enters the United States, then your fiancé can be eligible to come to the United States. Very often people ask me that what are the most important considerations in a fiancé visa. The intent to get married within 90 days is extremely important for a person who comes into the United States. Unfortunately, if you miss the 90-day deadline, you can wind up in troubled waters. So remember the most important thing for a K-1 fiancé. And today, especially we are discussing about the K-1. We are not discussing about the K-3 because K-3 is going to be a completely different issue we'll be talking about. So please do not get confused about today's program. And we are specifically focusing on the K-1 visa, commonly referred to as the fiancé visa, wherein people want to come to the United States and get married to an American citizen. So Sandeep, what are your thoughts on the K-1 visa at this time?
So what happens if I don't marry my fiancé in that 90-day limit?
If you don't marry your fiancé in that 90-day limit, I mean, that is not a good thing because the law on the point is extremely clear that the marriage has to occur within 90 days. Now, for some reason, if you don't get married within the 90-day period, the officer can deny your visa. And after that, you may have to go back to your country, apply for a visa again and come back over here. But that can also get into a lot of complications. For example, if your visa gets denied here and you got married after 5 months or so, and therefore in those cases I would say that you rush back, especially if you get denied over here and somehow get your status, get the visa processing done, because by law, I mean after the expiration of your authorized stay, which would be 4 months, and after that, if you accrue unlawful presence, you're looking at a serious problem in connection with the fiancé visa issue.
So during my 90 days here with my fiancé, my U.S. citizen spouse, what if I decide I don't want to marry them? Do I have to go back immediately?
Now, Sandeep's question is that you came to the United States and you are the fiancé of the American citizen and you decided that you don't want to get married to this particular individual. Very bad. My recommendation is get married. Try to make things work. Or if not, go back to your home country. This is very important because the sad news for you is that if you do not get married to this particular individual and if he does not apply for your immigration documents, you can wind up in troubled waters. Why will you wind up in troubled waters? Is because even if you divorce this particular individual or if you don't get married, in future, if you're thinking about getting married to someone else, unfortunately, you will not be able to adjust for a green card in the United States, which means you will be unable to get a green card in the United States. You will have to go back to your home country. So, Sandeep, we've had many questions in this regard from people. And over the years, recently we had a query from a client from Missouri who said that, Mr. Gehi, I came here and I wanted to handle my case at this time. I asked him what are the facts and circumstances of a case. He said, I came on a fiancé visa. I did not get married, but I have great news for you, Mr. Gehi. I said, fantastic. What's the great news? Now I found somebody else I want to get married. I said, too bad for you. Unfortunately, even if you get married to this American citizen now, you will have to go back to your home country, because since you came on a fiancé visa, you're not allowed to, you were required to get married to this particular person within 90 days and apply for your documents. Since you did not, you have violated the law and you'll have to go back. Now, the issue in this case is that what happens if this person thinks about going back to his home country? When he goes back, and if he has been illegal in the United States for more than 1 year, he accrues the bar under Section 212 of the Act, the unlawful presence bar. Therefore, if he's been illegal for more than 6 months, he accrues the 3-year bar. But if he has been illegal for more than 1 year, he accrues the 10-year bar. So in these cases, if they go back, they'll have to apply for a waiver, and of course it's not impossible to get the waiver, but you have to show extreme hardship. And if you meet the criteria, then he can come back on a green card to the United States.
Now, what kind of evidence does the consulate require for the fiancé visa?
It's very difficult to say, especially because, we've handled tons of fiancé visas over the years, and the lawyer has to work with the client on a one-to-one basis, because sometimes people think, oh my God, it's such a simple document for me to just fill out the immigration form and send it to, and my fiancé is going to come here. The procedure is not that simple, especially because when your fiancé goes there for an interview, if she does not have proper documents, and if she does not present herself properly before the consulate, you're looking at a denial of a fiancé visa. And nowadays, it is not unusual for us to find a denial coming to our office, wherein people have said, well, we tried initially on our own. Now the sad news is that, that the consulate is asking for more documents and the case is being denied. So Sandeep, you better be careful when you're looking for a good fiancé. If you want her to come to the United States, see that you do her documents properly. Otherwise, unfortunately, it's going to be a Romeo and a Juliet story, but you'll be the Romeo here and your Juliet will be in a foreign country.
Huh.
How would you like that?
Doesn't sound very nice. What kind of, is there an interview for the fiancé visa?
Yes, there is an interview which is required from the spouse. The spouse goes for the interview, the foreign spouse, and after that, if the consular officer is convinced. Now, this is becoming a big bone of contention, because recently, we got a case wherein quite a few people contacted us and says, my fiancé visa was denied. I did the paperwork on my own and the papers were so simple. The bottom line is, because when the fiancé went for the interview, she did not have the requisite documents. She was not properly prepared to address the questions before the immigration officer at the consulate, and therefore the consular officer, I would say, and thereafter, basically, the consulate issued a decision that they are not very convinced with the relationship. Now, that can also be a blemish on your record, because what happens is that, unfortunately, your fiancé's file is registered with the consulate. So even if you're intending to get married to her, the burden of proof can be high in those cases, because initially the consulate was not satisfied about this particular case. And since the case has been denied, the burden of proof can be higher in future.
What kind of questions do they ask at the interview?
The consulate may ask you everything about the relationship. They can ask you, a lot of questions, because you have to understand that they have wide discretion in asking questions. And if you're not fully prepared, and if you commit some fatal flaws during the interview, you're looking at a denial of the fiancé visa.
As a U.S. citizen, should I be at the interview with my fiancé?
It's a good idea for you to be there, But if you are not there, it's fine too. But generally, if you're there, it helps a lot. But there's no mandate that you have to be present at the interview. Now, what happens sometimes, Sandeep? People apply for the fiancé visa. And during the pendency of the fiancé visa, they secretly get married in their home countries. That happens a lot in many cultures. Is that correct? The answer is no. That is extremely wrong. Why? If that happens, immediately get in touch with any attorney that you like. The reason that is important is because you violated the requirements of the visa, and especially if you're going to go for the interview and let them know that you've never been married, and if the consular officer finds out that you are actually married, you're looking at a fraud. And if that fraud becomes an issue in the case, unfortunately, even if you get married to her later on, she may not get the visa, because granting the waiver or not granting the waiver, it's completely up to the consulate over there. So be very careful if you have wound up in such a situation.
Can my dependent children under 21 join me on my fiancé visa?
Yes, your dependent children under the age of 21 can join you on a fiancé visa, and they can come to the United States.
Are there any requirements for them?
Well, basically, they have to show that they're related to the mother or to the father, and of course, you need to prove the documentary trail to show that they actually qualify, and accordingly, they will be issued a visa, and they can come together to the United States.
Now, typically, why do K-1 visas get denied?
K-1 visas get denied because people are sometimes very overconfident. They think it's a very simple document, let's fill it out, and after that, let's send it to the consulate, and they actually say, oh my God, it's so easy. But when they realize that the consulate did not grant the visa, that's the time when they start panicking and they say, what happened? And it's better for you that if you are an expert, of course, you should proceed with the paperwork on your own if you're an expert. But there's no substitute to legal advice in these matters, especially. Now, something very important that comes to my mind here is that very often people ask me that, Mr. Gahi, my fiancé came to the United States here. What do I have to do? My recommendation is that immediately get married. Because if you get married, then you can apply for the adjustment of status of the fiancé in the United States and qualify her for permanent residence. Now, that is very important, because if you do it correctly, and the good news is that, your fiancé will be able to get the green card pretty soon. If you don't act in an appropriate manner, you're looking at opening up a can of worms, and you're looking at a denial from immigration perspective.
If I'm in the United States with my U.S. citizen fiancé, what if my fiancé is abusing me? Should I stay and still get married to him, or should I go back to my home country?
My recommendation is that if you're not married, go back to your country. But if you're married to him and if you're a victim of abuse, there's nothing for you to worry about. A good lawyer can help you, because the bottom line in that case is that you have a special provision under the law, which is known as the battered spouse provision, through which you can still qualify for a green card. Similar case that I handled was about a while ago from a person from another state who thought that there was no relief available to her, and she was newly married, actually, just married for a couple of months, 5 or 6 months, and the husband was not ready to help her with a green card by sponsoring her. So what we did in this case is that we went under the battered spouse provision, and the person did qualify for a green card. So remember, there can be light at the end of the tunnel. Do not give up on your immigration matter. Especially sometimes this is another issue that happens. I remember an issue wherein a person comes into this country as a fiancé. The couple gets married, and after that, it so happened that the U.S. citizen spouse never applied for a green card, because they were fighting day and night, and he always threatened that he was going to get deported. And the spouse was petrified. And finally, what happened one day, she was traveling, and she took a bus, and she wound up, somewhere towards Buffalo, and immigration caught her. And after they caught her, we got her released, and later on, we were able to help her in that case, and we found out later on that she was a victim of abuse. So remember, even if you're new to this country, and if you are facing abuse after your marriage, you don't need your husband's signature. You can still qualify for a green card. So that is something very important that people have to know in this country.
Will my criminal history affect my eligibility for the fiancé visa?
If you're a foreign national, if you have a criminal record, yes, that can have an impact on your immigration matter. And in this case, but that does not mean that you may not be eligible for visa, but you may need specific kind of waivers. And I think that's a question that they should be deferring to the lawyers in this particular situation, I believe so.
Well,
So, Sandeep, what we're going to do, I think you're asking me a lot of interesting questions. We're going to take a short break and we'll be back again. Don't go away. Keep watching. We'll be back after the short break.
In deportation, do you have a complex immigration matter? Has your immigration case been denied? For all your complex immigration matters, including family-based immigration, employment-based immigration, deportation, citizenships, battered spouses, call Gahey & Associates at 718-263-5999 for a free initial consultation.
Over the years, we've helped many people in getting the green cards. Would you like to have your green card? Call Gahey & Associates now. Sandeep, thank you for asking me so many wonderful questions, but I have a surprise for you. I have a lot more questions from our viewers, which were personally addressed to me. So I'm going to answer those questions, and we'll see, how we can assist our viewers to get their fiancés to the United States. Thank you again, Sandeep, for those questions. The first question which I got was, Mr. Gahey, my fiancé went for an interview, and before the consulate, for the fiancé visa, and the sad news is that she got denied. What should I do? Firstly, I'm very sorry to hear that your fiancé got denied. This means your preparation was not adequate. In this case, there's nothing for you to worry about. You may still have light at the end of the tunnel. What you need to do is that you should definitely consider retaining an attorney, especially because the burden of proof may be much higher on your case, or there may be an alternate avenue for you to actually get your fiancé or your spouse to the United States. So it's important for you, if the case is denied, do not lose hope. You may still be able to get your fiancé, or in future, if you get married, your spouse to the United States. That was the first question. Second question was, Mr. Gahey, I was married 2 times before in the United States, and I divorced both my spouses, and they came initially on a fiancé visa, they married me, and they both left me. Now, I'm going back and getting married to somebody else. I think you definitely need to be very careful, because you have to understand that you have sponsored 2 people in the past on a fiancé visa. You got married to them, but unfortunately things have not worked out for you. Now, when you are going to get married to someone for the 3rd time, you are looking at issues coming up, and the questioning will be a lot more than you can imagine, especially because the consulate wants to ensure that the initial relationships that you had with the earlier 2 women were bona fide, and they were not intended to circumvent the immigration laws of the United States. So this is something that is a complex issue, and you need to be very careful when you apply for your fiancé visa. This does not mean that you won't be able to get your fiancé to the United States, but you may be having a lot more obstacles than you can imagine if the consulate reviews the entire matter thoroughly. Next question was from a viewer who said that, Mr. Gahey, I've had issues with my fiancée. She came to the United States, and at this particular point of time, we both are not getting along. And however, it's not been 4 months. What should I do? You need to talk to your fiancée. Either consider getting married or asking her to leave the United States. There's nothing in between for her. Even if you are a kind man, that's the only thing you can do, because even if she's going to leave you, and if she's going to consider getting married to someone else, she's not going to have any luck, especially because the laws on this point are extremely clear that you have to get married to your fiancé within the 90-day period. The next question which I got from a viewer was that, Mr. Gahey, my fiancé came into this country, we got married, we went for the initial interview, and the officer was not satisfied with the interview. What happened? What happens next? I said the answer here is that you will be scheduled for a Stokes interview wherein you both will be separated. I call a Stokes interview as a harrowing experience. It's not the best experience you can ever imagine. Especially these cases happen when you apply generally, when you get married to an American citizen, and if the officer is not satisfied at the first interview, you both will be separated. And I must tell you that in these cases, especially be very careful. The Stokes interview, my personal opinion is that it's more like a do or a die interview. And if you fail that interview, your case can be extremely complex and difficult. I'm not saying that you cannot succeed later on, but it can be a miserable experience for people. So in this case, if your initial interview, if you failed it, see that for the second interview, you're very well prepared and somehow go with the best possible lawyer that you can imagine and get it out of your way. Because if you fail that interview, you're looking at some serious problems for your spouse. Next question was from a viewer that Mr. Gehi, my fiance came into this country, we got married, and she got her 2-year green card. Now things are not working out. A lot of my clients who come in and see me tell me that, Mr. Gehi, now I got my 2-year green card and my spouse is not ready to help me, my American citizen spouse. Don't worry about it. If you married him in good faith, and if you have enough evidence to show that you had the intent of establishing your life together with him, a qualified lawyer can fight your case and still get you your 10-year green card. So don't be disappointed and leave the country because people think that life is going to be miserable. And I believe that also my husband, who's an American citizen at this time, is threatening me that he's going to get me deported. See a qualified lawyer. See a good immigration attorney. He will be able to help you because, I mean, the most important thing in immigration law is your intent to not circumvent the immigration laws of the United States. We've had cases like this wherein people have come in with complex matters, but remember, if you are genuine, you can succeed in this country. Sandeep, it's been great to have you on the show, and you had very, 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 very important questions. Looks like it that probably you intend to get your fiancé to the United States. This is something unique I observed in this particular program. This program, I can call it special, unique, and extraordinary because I thought you've done a lot of your research, plus you've asked a lot of our viewers to actually send emails. But what we're going to do is that we're going to continue with some more interesting news and keep watching this program, viewers, brought to you by K-1 Associates, attorneys and counselors at law. And if there's a particular immigration show that you are interested in, feel free to email us by visiting our website at www.immigrationquestion.com.